and welcome to Disability Rights South Dakota's legislative update for the week of February 21, 2023. We're well into the legislative session this year, and a lot of the bills that we'll be talking about have already been signed by the governor, therefore waiting to become law. Some of them have been sent to the 41st day, therefore are dead in the legislature and will not become law and will no longer be discussed. And some of them continue to work their way through the committees and chamber floors for discussion, whether they be amended, sent to the 41st day, killed on the chamber floor, or sent to the governor for signature. You can see here that we have several House bills that we'll be talking about, some concurrent resolutions, and Senate bills. Let's get right into it. House Bill 1010. Repeal the sunset date for provisions related to the licensure of behavior analysts. This removes the sunset provision of the session law, which would allow that session law to remain in effect after July 1, 2024, which was the date previously set for it to end. This bill has been signed by the governor, and therefore that repeal will go into effect. House Bill 1034, modify tax refunds for elderly persons and persons with disabilities to make an appropriation therefore and to declare an emergency. This bill creates a fund of $450,000 to provide refunds to elderly and disabled persons for real property tax and sales tax refunds. It also increases income limits for eligibility to receive these funds. This bill, too, has been signed by the governor. House Bill 1037, amend the eligibility for admission to the state's Veterans Home and repeal the residency requirement. This bill has been sent to the 41st day by the Senate Military and Veterans Affairs Committee, and therefore is dead legislation. It will no longer be discussed. It will not move to the governor's desk. This bill is dead in the state capitol. House Bill 1044, establish scholarships for individuals pursuing careers in the behavioral health field to make appropriations therefore and to declare an emergency. This bill appropriates $5 million to administer a $15 million scholarship to fund supports for students pursuing behavioral health careers and professionals entering the behavioral health field. This bill was hog-housed on January 26th and amended. That means it was significantly changed in some way. What was that change? It added significant amounts of language in order to administer the scholarship and described the eligibility for fields of study. This bill continues to make it through the House, has been sent to the Joint Committee on Appropriations, which of course is where money is discussed, funding is discussed. This has been scheduled for hearing with the Joint Committee on Appropriations in room 362 on Thursday, February 23rd, and they'll discuss this item between 8 a.m. and 12 p.m. on that date. House Bill 1046, to provide free tuition at the Board of Technical Education Institutions for children or spouses of members of the South Dakota National Guard who were disabled or deceased in the line of duty. Currently in South Dakota, individuals who are children or spouses of the National Guard who were disabled or deceased receive free tuition at Border Regions institutions such as USD, SDSU, Northern State, Black Hills State University, and others. What this bill would propose to do would be to add technical colleges in the state to free tuition for these individuals. This bill has been scheduled for hearing in room 423 on Tuesday, February 21st from 8 a.m. to 9:45 a.m. and will be heard by Senate Education. House Bill 1052, change the eligibility requirements of a property tax relief program for disabled veterans and surviving spouses. This bill has been referred to the 41st day by House taxation. This bill is dead in the legislature. House Bill 1078, make an appropriation to the Department of Human Services for the development and expansion of adult day services programs and to declare an emergency. This bill would appropriate $5 million for grants to DHS, or the Department of Human Services, for the development and expansion of adult day services that serve adults with dementia or symptoms of dementia. This bill has been scheduled for hearing with the Joint Committee on Appropriations in Room 362 on Thursday, February 23rd, from 8 a.m. to 12 p.m. House Bill 1079, make an appropriation to the Department of Health to provide grants to support mental health and suicide prevention programs and to declare an emergency. This bill would appropriate $4 million to the South Dakota Department of Health for grant programs directed toward youth and young adults that provide mental health and suicide prevention peer support training, community mental health and suicide data services, and suicide loss response planning and support services. This bill has been scheduled for hearing before the Joint Committee on Appropriations in Room 362 on Thursday, February 23rd, from 8 a.m. to 12 p.m. House Bill 1086, create provisions for the psychiatric collaborative care model to reimbursable for insurance. This bill has been deferred to the 41st legislative day and will no longer be heard by the South Dakota Legislature in 2023. This bill is dead in the South Dakota Legislature. House Bill 1103, waive the fee for non-driver identification cards for individuals at or below poverty level. This bill has been sent to the 41st legislative day. It is dead in the legislature and will no longer be heard. House Bill 1128, revise provisions pertaining to absentee voting at nursing facilities, assisted living centers, or hospitals. This bill has been deferred to the 41st day. House Bill 1138, require updated cost report information for certain community-based health and human services providers. This bill requires an annual update of cost report information for community-based health and human services providers. The bill strikes language allowing DHS and DSS, so the Department of Human Services and the Department of Social Services, to conduct these updates upon their subjective assessment of need or based on cost report information or market conditions. So what this does is it requires that the Department of Human Services and the Department of Social Services create an updated cost report on an annual basis. House Bill 1167. Annually adjust the rate for community-based providers to 100% of methodology. This simply means that community-based provider must be set to 100% of the methodology annually. So basically what it costs to support people at community support providers must be reimbursed by the state based on that methodology every year. This has been scheduled for hearing and will be heard before the House Committee on Appropriations in Room 362 on Tuesday, February 21st, from 8 a.m. to 12 p.m. House Bill 1174, revise civil commitment procedures for offenders with developmental disabilities. This bill defines the criteria of immediate danger of physical injury to self or others. It also defines the scope of offenses for which civil commitment can be sought once criminal charges have been dismissed. This bill has been referred to Senate Health and Human Services and has not yet been scheduled for hearing there. House Bill 1195, continued enhanced and transitional rates for community support services and support providers. This bill states that the Secretary of the Department of Human Services must continue fiscal year 2023 enhanced and transitional rates for community support providers and community support providers as defined in South Dakota Codified Law 27B-1-17. The rates in this section must be annually adjusted for inflation. This bill will be heard in the House Committee on Appropriations in Room 362 on Tuesday, February 21 from 8 a.m. to 12 p.m. This is an interesting bill that Disability Rights South Dakota is following very closely. If you have any questions about this bill or the underlying issues that it purports to address, please contact us and we'd be happy to talk with you about House Bill 1195. House Bill 1217, modify the requirements for eligibility to vote by absentee ballot. This bill defines circumstances one may vote by absentee ballot. The circumstances include, but are not limited to, permanent and total physical disability, illness, or temporary physical disability. Absentee voting used to begin 46 days before an election. Under this proposed legislation, absentee voting begins 30 days before the election. So it's a 16-day reduction in the number of days you have available to vote absentee. Unless you're overseas citizens or military personnel, you still have 46 days to submit an absentee ballot. This bill also proposes to eliminate the use of drop boxes in this state. If not now, certainly any use of them in the future. This bill has been heard by the House Local Government Committee, and they have voted to pass that. It will go to the House floor for discussion. House Bill 1218. Amend documentation requirements for emotional support animals in a rental dwelling unit. This would make it so that if you're a person who needed an emotional support animal in a rental, that you needed to get a note from a doctor in South Dakota. This bill has been sent to the 41st day and will not be heard by the South Dakota legislature again this year. House Bill 1240. Amend provisions addressing guardianships and conservatorships. This bill proposes to amend South Dakota Codified Law regarding conservatorships and guardianships. It adds a section which would require a report from a licensed psychiatrist to be submitted with a petition for guardianship or conservatorship if the subject of the petition or the person for whom which the protection was sought contest the action. If they don't want a conservator, if they don't want a guardian, then the law would state that there has to be a report from a licensed psychiatrist to go along with the petition to the court. The legislation also adds that a power of attorney must be nominated as a guardian or conservator nominee. That is to say, if a person has a power of attorney with somebody and somebody is seeking to get guardianship over that person, the power of attorney must be considered as potential guardian or conservator for that person. And finally, the bill amends certain reporting requirements of appointed guardians and conservators. This bill has passed through House Judiciary and will be heard on the House floor. As you can see here, there's a lot that goes into this bill. It's really important legislation for people with disabilities, specifically intellectual developmental disabilities, who may be in a situation in which guardianship is sought. Again, this bill states that if an individual has already identified somebody as being their power of attorney, that should be taken into account when a determination or discussion is had about appointing a guardian. That power of attorney should be able to be considered as being a guardian or conservator should the need arise. You can see here that if a person disputes a petition, contests that a guardian or conservator be appointed, they can ask that a physician, psychologist, or psychiatrist of the person's choice may or must provide a filing with the petition showing the need or lack thereof for the appointment of a guardian or conservator. You can see this legislation. Some of the legislation has been stricken. It strikes some of the previous statute and adds in other areas. It's quite lengthy. And again, this is House Bill 1240. So if you'd like to discuss this bill in more depth, please call us and we'll be happy to talk with you. House Concurrent Resolution 6002 to encourage the Executive Board of the Legislature to continue researching childhood mental health and mental health services available to children in this state. These resolutions are non-binding. They encourage some act or they recognize an individual or an act. That's important to note. This bill has been referred to the Senate Health and Human Services Committee. It's already made it through the House and will be heard by the Senate. It has not yet been sent to the Senate floor. Correction. It has been sent to the Senate floor. It was sent to the Senate floor on a consent calendar. While there, the Senate can decide whether or not to leave it on the consent calendar and just pass it as a package of bills that were on the consent calendar, or they can elect to pull a bill from the consent calendar. In this case, that's exactly what they did. They pulled it from the consent calendar and they referred it back to the Senate Health and Human Services, where it'll again be heard and whatever issues that need to be hammered out, it'll be done so that it can go back to the Senate and hopefully there be passed. House Concurrent Resolution 6003, again non-binding. This is encouraging the Executive Board of the Legislature to authorize the interim legislative study of a long-term care services for veterans regardless of disability ratings, and to develop long-term care plans for VA-operated, purchased, and subsidized long-term care services. It's a mouthful, doesn't really matter. It's been deferred to the 41st day and therefore is dead in the legislature. Yes, a concurrent resolution has been referred to the 41st day and is dead in the legislature for this year. Senate Bill 1, modified debilitating medical conditions for medical cannabis use. This bill defines qualifying medical conditions for medical cannabis use. It removes the authority of the Department of Health to add conditions to the list of authorized medical conditions. And also, of course, it removes South Dakota residents' ability to petition that Department of Health to add qualifying conditions. So essentially, it sets up a static list of conditions that an individual may have that would qualify them to receive treatment with medical cannabis. This has made it through the Senate and has been sent over to the House and referred to House Health and Human Services. It has not yet been scheduled for hearing. Senate Bill 2 revised the Department of Corrections reporting requirements concerning abuse and neglect of individuals in private contracted facilities. This is basically a language cleanup. It defined by the date by which the Secretary of the Department of Corrections shall provide a report to the Government Operation and Audit Committee, also known as GOAC. That report must be sent to the committee no later than July 31st of each year. This bill has been sent to the governor and has been signed. Senate Bill 4. Modify a court's authority to commit habitual juvenile offenders to the Department of Corrections. So this adds a little bit of language. The statute currently reads that the court may only commit a child to the Department of Corrections if the judge finds that A, no viable alternative exists, B, the Department of Correction is the least restrictive environment, and one of the following. The child is currently adjudicated delinquent for an offense eligible for transfer proceedings pursuant to state law. The child is currently adjudicated delinquent for a crime of violence pursuant to subdivision 22-1-2, section 9, a sex offense, a felony sexual registry offense, a burglary in the second degree, or the court finds from evidence presented at the dispositional hearing or from the pre-dispositional report that the youth presents a significant risk of physical harm to another person. Now, that's the way the law currently reads. This bill would add the language that in the alternative to that previous section about all these different crimes, the child has been previously adjudicated delinquent for a separate act arising out of a separate and distinct criminal episode within the preceding 12-month period. So it's kind of a two-strike deal. If in the last year you've had a separate delinquent act or criminal episode, then the court may adjudicate and send you to the Department of Corrections. This bill has made it through the Senate and has been sent to the House Judiciary Committee and is not currently scheduled for hearing. Keep an eye out for that. Senate Bill 6. Authorize community response teams to recommend the alternative community-based resources for children alleged to be delinquent and children alleged to be in need of supervision prior to adjudication. This adds representative of public school district as a required member of community response team that the court may seek recommendations for community-based interventions and rehabilitative resources prior to disposition to the Department of Correction as a child in need of supervision. So there's a community response team, an intervention team, and what this bill does is want to add somebody from the school district to be on that team to advise the court as to other options that may be available prior to referral to the Department of Corrections. This bill has made it through the Senate and has been sent over to the House, which referred it to the House Judiciary Committee, not yet scheduled for hearing. Senate Bill 7, clarifying emergency commitments of severely mental ill persons by appropriate regional facilities. This bill adds appropriate regional facility as an alternative to a hospital and mental health holds. This has kind of been the standard. This has been the case anyways, but it just cleans up the language. It's important to note that there are areas in the state in which an appropriate regional facility or a hospital is not an option available to individuals in mental health crisis. In those instances, they may be put on a hold within a county jail until they can have a hearing on whether or not they must be involuntarily committed, or perhaps their condition stabilizes and they may be released. This bill has been signed by the governor and will therefore become law. Senate Bill 9 modifies discharge notice procedures applicable to developmentally disabled persons. This applies to individuals at the South Dakota Developmental Center, also known as SDDC. If a parent or guardian voluntarily admitted a person to the South Dakota Developmental Center, they being the parent or guardian, must no longer receive 10 days notice prior to that person's release. Instead, if a client is to be either transferred or discharged, the facility must have documentation in the client's record that the client was transferred or discharged for good cause, and provide reasonable time to prepare the client and or his parents or guardian for transfer or discharge, except in emergencies. So what this does is it changes the language from 10 days notice to a reasonable amount of time. This bill brings the state law up to the current federal law. So it makes it match current federal law. This is actually a good thing. It seems like in part it's not. 10 days is 10 days. That's a defined amount of time. However, under this law or under this bill, if it were to pass, it would provide a reasonable time to prepare a client and or his parents. So sometimes a reasonable time is less than 10 days for arrangements to be made, alternative placement to be obtained, what have you. And sometimes it's more than 10 days. So this makes sure that there is a adequate supports in place prior to the discharge or transfer. This bill has been delivered to the governor on February 15th, but it's sitting on the governor's desk, has not yet been signed. Senate Bill 10 expands certification options for interpreters for the deaf. This bill proposes to expand certification requirements for interpreters for the deaf. It would expand the availability of qualified interpreters to the deaf community. This legislation is supported by DHS and groups from within South Dakota's deaf community. So before, there was just a very limited, narrow sliver of certifications for interpreters that were authorized or approved by state government. And this expands that list to other certification resources or sources. And this is just going to make it easier for people to find interpreters, qualified interpreters, and provide that service in this state. It has been delivered to the governor. It sits on the governor's desk, and we'll see whether or not she signs this bill. So keep an eye out for that one. Senate Bill 37, revised provisions pertaining to the South Dakota School for the Deaf. This updates statute to reflect the language change from South Dakota School for the Deaf to South Dakota Services for the Deaf. It's a name change that occurred with that institution, so it's just kind of a cleanup so that it reflects that. It also updates and expands background checks for certain positions at the South Dakota School for the Blind and Visually Impaired and Services for the Deaf. So just making sure that everybody's safe and that there's adequate background checks being occurred there. This bill has been delivered to the governor, and it too is sitting on her desk, awaiting signature or veto. Senate Bill 64, repeal provisions related to the Jail Mental Health Screening Pilot Program and Oversight Council. This eliminates the Jail Mental Health Pilot Program and its Oversight Council and its reporting requirements. I spoke with Senator Duhamel on this bill, and she informed me that this was a pilot program that was instituted but never really took off in the state. The language cleanup of this bill would basically amend state law so that these responsibilities previously put upon this pilot program would go back to the various county jails, which according to her were already doing this function. So essentially there's a pilot program that was put into place. It never really got any legs, and they're just cleaning up the statute so that it doesn't reflect the use or the existence of this pilot program anymore. This bill has made it through the Senate entirely and has been sent over to the House and has been referred to House Judiciary. Senate Bill 91, revise certain provisions regarding the crime of rape and provide a penalty therefor. This bill is being closely watched by the South Dakota Network Against Family Violence and Sexual Assault. It adds language to the statute defining rape to say that a perpetrator of such act must know or should reasonably know that a victim lacks capacity to give consent to sexual activity. It could create an enhanced burden of proof for the state to prosecute the crime of rape committed against a person with diminished or mental or physical capacity, in that the state would have to prove that the person knew or should have known that the person lacked capacity, or that the person knew or should have known that the person failed or didn't give consent. This bill made it through the Senate and has been sent over to the House Judiciary. It has not yet been scheduled for hearing. Senate Bill 161. This is an appropriation bill which provides $313,107. Yes, that's an appropriation of $313,107 on the nose to the Secretary of State's office for, among other things, ballot machines which may be used to facilitate accessibility to the voting process for people with disabilities. So we like that. We like ensuring or expanding accessibility in voting. So that's one of the things that this bill would propose to do. It has been sent to the Senate State Affairs, who referred it on to the Joint Committee on Appropriation. It's been scheduled for hearing by the Joint Committee on Appropriations in room 362 on Friday, February 24th, 8 a.m. to 12 p.m. Senate Bill 177, to provide for the study of a developmental disability services and provide an appropriation therefor. This is another bill that Disability Rights South Dakota is watching very closely. We've been involved in discussions surrounding this topic. This bill proposes to bring in a third party to do a study of DD services in the state. Eligibility, services that are being provided, just a various review or study of what we're doing well and what we might be able to do better. This bill has been scheduled for hearing to be heard by the Joint Committee on Appropriations in room 362 on Thursday, February 23rd. From 8 a.m. to 12 p.m. If you have any questions over this one, we'd be happy to speak with you about that. This is something, again, that we've been really interested in and really involved in. I think this is an important bill that the people in South Dakota with disabilities or family members of individuals with disabilities should really keep a close eye on. Senate Bill 206, clarify good cause for the purpose of continuing an individual... Senate Bill 206, clarify good cause for the purpose of continuing an involuntary commitment hearing. So, this bill adds a little bit of language to involuntary commitment hearings, which states that awaiting the completion of an independent examination is not good cause for continuing a hearing under this section. So just waiting around for an independent examination is not a good enough reason to extend the time in which a person can be held for some sort of mental health issue prior to commitment hearing. This bill has had quite a life already. It was sent to Senate Judiciary. It was amended there. They passed it through the Senate Judiciary uncontested. That is to say that Senate Judiciary Committee passed it with 7 yeas and 0 nays. It was certified and placed on the consent calendar. Once it reached the Senate floor, it was pulled from the consent calendar and will be either discussed on the Senate floor or sent back to committee for some sort of changes. So we'll see how that goes. Senate Bill 208 require financial institutions to report exploitation of an elder or an adult with a disability. So this basically requires that financial institutions who observe or have reason to believe that a financial exploitation is occurring with one of these individuals in one of these groups must report the information contained in that suspicious activity report to the Attorney General. So it kind of makes these financial institutions mandatory reporters, and they must report it to the Attorney General. What's happened with this bill? State judiciary has tabled this bill. They haven't killed it. It's not deferred to the 41st day. They haven't passed it. It's not moving on to the Senate floor. It's just going to sit there. It's going to sit there until a majority of the Senate vote to compel Senate Judiciary Committee to move that forward to the Senate floor, or they just leave it alone, in which case the session will end and no action will have occurred with this bill. So we'll see. This bill's been tabled. It's really in limbo. It's interesting on that one. That's all the bills for this week. It's a ton of bills. So as you can see here, these are all the ones that we've gone through. If you have any questions about anything that I've covered here today, specifically some of the bills that I pointed out that Disability Rights South Dakota has been watching and participating in, educating our legislators and policymakers, give us a call at 605-224-8294. We also have a 1-800 number that will be shown at the end of this video. Give us a call, and we'd love to talk with you about any of the things that we're watching here with the South Dakota legislature in 2023. One other thing to note that we'll be at Disability Awareness Day at the Capitol, starting right at 8 o'clock a.m. in the Capitol Rotunda on February 22nd. So if you'd like to meet with us, swing down. There will be a bunch of different groups from the disability community down there. Meet with us, and we'll introduce you to legislators and other people at the Capitol that we work with on a daily basis. We're really excited to see you there, and we hope to put out another video next week covering the status and the progress on all the bills that we've talked about here, and as we wind down the legislative session, point out the ones that are being implemented as law and the ones that had a shot this year and didn't quite make it. So again, have a great week, and thanks for listening in, and we look forward to speaking with you next week.